Hello everyone, it's Rick. It's May the 22nd, 2017. If you need to contact me, it's Rick0327 at me.com. Alright, what you're looking at here is the Constitution. Okay, and that's not the reason why we're here. What I'm going to show you is, how my paperwork boxes people in. And I'm going to give you an example. If I can just find the damn thing. All right. See here, this is a response from the Monroe County Department of Human Services Child Support Enforcement Unit, upstate New York. Okay, my buddy Bob, who's a beast, he likes fighting these people, and he's getting close. What my paperwork does, I box these people in. That's what I keep telling you guys. I don't get into these arguments about child support and all this other stuff. I like to nitpick them. I go after them by showing that they're not following their own procedures. I also like saying, well, that supposed court order, that supposed support order is invalid. Okay, it looks like a court order, but it's not a court order. It's not signed by a judge. It needs a judicial signature. Okay, all writs of process in the United States must be signed by a judicial officer, because all cases arising under law and equity is under the judicial branch, not the executive, not the legislative. Okay? In New York State, our Family Court Act 439, which is for these support magistrates, and I guarantee you in your state, all you gotta do is look it up for your commissioners or whatever they are, associated judges, whatever they are, wherever you're from. I guarantee you, if you look it up, all of their orders must be either reviewed or signed by a judge. Okay, in New York State, Family Court Act 439 says that all support orders must be confirmed by a judge or they lack legal force. Okay? That means it's nothing, it's void. But they never sign it. So what I do is I go after that stuff. Okay? And another thing I discovered was the undertaking. Okay? An undertaking is an agreement. They keep calling us obligors. They keep using words like obligor and obligation to a debt. And what I do is, okay, well, can you just please show me proof that I'm an obligor? Now, we've been over this many times in my videos, that one of the hardest things to do is to have these people actually show proof when we ask for it. Excuse me. So, our friend Bob here did that. Okay, let me see if I can make this bigger. I apologize. Okay. This letter is in response to the notice I received from you, postmarked May 3rd, 2017, entitled Demand Proof of an Undertaking for Payment of Child Support through Title 4D Collections. Be advised that this office will not respond to any demands that may be included in the notice. Okay? Well, they're not cooperating. Bob's just asking for a simple proof of an obligation. You're telling me, I got to pay child support. You have absolutely no problem sending out all these notices to my job, to the bank, whoever, calling me an obligor, claiming I owe a debt. And I have every right to see the debt, but you guys don't want to cooperate. Excuse me. So, let's see what the undertaking looks like that they're afraid to answer. Okay? So, sent out. The intention of this communication is the undersigned is demanding proof of an undertaking for title for a loan or service requiring repayment of child support debt obligation through a Title 4D collections. Okay, now what we're going to say here is, oh, by the way, if you don't respond in this certain way, it's a default. Okay, a default by this Title 4D collection agency shall be defined as silence or intentional refusal to comply with this demand for proof of an undertaking for child support obligation. Notices for debt for child support has been sent by this Title 4D collection agency that has termed the undersigned an obligor, who is obligated to comply with an alleged obligation to pay child support by income withholding order. All of these support hearings, guys, are really income withholding hearings. That's all they really are. It's another scam what they do. They disguise everything, okay? Because the first thing that they do when they trap you with their kangaroo court, and listen, guys, it doesn't matter what you do or say in there. You're guilty no matter what. I know of no one who has gone in there and actually walked out victorious. Because they just, doesn't matter what you say, doesn't matter what you demand, doesn't matter what proof you bring. I mean, I walked in there with every kind of proof you can bring that I didn't do anything wrong. And, 6 years later, I finally got my support order vacated. Okay, so it doesn't matter. Okay, but what we got to do here is we got to go at them in different ways. Okay, and again, the first thing they do is they notify a child support agency, and the agency starts sending out these income withholding orders because that's their number one way of collecting child support. Okay, a couple of guys out there told you that their jobs stopped sending the child support and nothing's happened to them. Okay, there's nothing they could do to you. But they know the best way to get the money is to steal it by the income withholding order, which coincidentally looks just like an income execution order, which comes from the court. Looks just like it, but it's not. Please recognize that the response by the undersigned, your name, to this default will be a writ of mandamus to compel the discovery of an undertaking and a valid court order for child support in a court of proper jurisdiction. Remember a couple of videos ago, I'm telling you, I put Bob in the position now. Andre, upstate New York, I put him in the position, and he did it. And you know what they did? They're making a deal with him. Because I put him in the position. He did all the work himself. See, I can only put you in the position, guys. And Amin Osiris says the same thing. I can only give you the tools. The rest is up to you. Okay? So, Bob, I have no reason to doubt Bob, because Bob's an animal. He's a beast. Okay? He sent this to me, and I was like, oh my God. He was like, what are they afraid of? You know what they're afraid of. They can't prove it. Okay? So, we boxed them in. This is why my paperwork, some of them are a little long-winded, because what I do is I box them in. I don't give them any way. I try to eliminate a month or 2 months of going back and forth with them. Oh, you didn't show us this. You didn't show them that. What I do in my paperwork is, oh yeah, by the way, if you try and claim that, court-ordered debt, you don't have to provide validation of debt. All right, well, show me the proof of the court order. Okay, they can't do it because there is no court order. Okay, court order must come from the United States court under 28 U.S.C. 1691. Okay, one of the guys in the comments section has had success clearing his credit by doing just that. By asking the credit bureau, well, show me the proof of the court order. That's always been my method. Show me a valid court order. Okay, if somebody is going to come to your house to search your house, what do you ask for? You ask for a warrant. Well, if the warrant is not signed by a judge or a clerk, recorded, there is no warrant. All right, there's a video, I believe I showed you guys in one of my videos, where a sheriff, uh, was working in conjunction with IRS. The IRS agents, what they normally do is they always have to contact the local law enforcement. The FBI does the same thing. And, they want the local law enforcement with them. So the sheriff, what he did was, he's like, well, can I see can I see the paperwork? And he's looking over the paperwork, and the paperwork is signed by the IRS people. So they're authorizing their own warrant. So he's like, hold on a second, this is not a warrant. A warrant under the Fourth Amendment must be signed by a magistrate from a court of record. This is what I nitpick at. I go after that. Okay? Some people out there, they claim there's no Constitution. I don't get into that. All I know is there's a black and white thing called a Constitution. Now, whether you believe it works or not, or it's there or not, I'm not going to get into an argument with these people. I believe it exists because it's still there. And I can still quote it. And people every day win lawsuits based on their rights being deprived. Happens all the time. They just don't advertise it. Okay? So what I do is I box them in with this. Excuse me about that. I got sinus problems. You hear my video all the time I'm doing that. I apologize. Okay? So again, I go after the support order being valid. We know it's not valid. I've done that in my lawsuit, and they keep ignoring me on it. They never say to me, well, it's an administrative order. You don't need a judicial. They never say that to me because they know they can't. Okay? All court orders must be signed by a judicial officer or it's void. Okay? Ninth Circuit Federal Court of Appeals says it, and I'm sure there's Supreme Court cases out there. There's plenty of cases out there for void judgments. That's what we're going after eventually. Writ of mandamus, and that's what I'm talking about here. Now, what I'm going to say to them, okay, well, if you refuse to comply with this discovery, this is what's going to happen. I'm going to take you, writ of mandamus is what I did right here. Please understand that a default for this demand will result in evidence. Oh, by the way, if anybody's watching this video, freeze it and add it to your undertaking affidavit. Okay? I'll do it nice and slowly, freeze it and add it because I just added this stuff for Bob. Okay? So I don't get, hey Rick, can you send me the updated thing? Well, guys, you can help me out a little bit. I'm doing nice and slow. Just freeze it and do it yourself. Okay? So what I say here is please recognize that the response by the undersigned to the default will be a writ of mandamus to compel discovery. Okay, I'm sorry, guys. Please understand the default for this demand will result in evidence presented in an open court showing that there is no undertaking for a valid child support, there is no undertaking nor a valid child support court order. And I put in brackets, in accordance with 28 U.S.C. 1691. Okay, it's a United States code that tells you what a writ must contain. All orders are writs. Authorizing this Title 40 agency, according of this past and present seizing property by income withholding. Okay, well, if they didn't have a valid court order in the past, they didn't have it in the present. That means everything they took from you, they got to give back. Further, there will be a record in an open court showing this Title 4D collection agency was never authorized to seize property, and its refusal to comply with this demand for undertaking is supporting the claims of deprivation of rights that will be brought in a federal court for efforts of concealment and obstruction. That's what this clown is doing here. This is nothing more than concealment and obstruction. And what he's doing here is he's saying, well, if you want this from me, you're going to have to take me to court. And that's what they're relying on. But, look at this, just in time. But, everybody who has my paperwork, and you did everything I asked you to do, you followed the instructions, you're all in position now to do this. You're all in position to go to the Supreme Court and say, I'm filing a writ of mandamus, and I need to see proof of discovery of evidence of an undertaking. And what I did here, what I showed him, what I'm saying to him is, and when you go there and you cannot show proof, first of all, it's going to be on the record. It's going to be recorded in the court. It's going to be recorded that you never had it. And also, I have to take you to court because you're refusing to comply with discovery, which, when it's shown that you never had an undertaking or a valid court order, you were obstructing. You're concealing evidence that you were never authorized to take my property. And it's going to be presented in a federal court for deprivation of rights under 18 U.S.C., which is crime. We're not talking a lawsuit here. We're talking a crime. So let's see how I react. Excuse me. Now, I'm going to go over this real slow because I'm going to end this video. It's 16 minutes. What I did here is basically I did the same thing. Nice and slowly. What I said here, I go, because I asked for, I asked for the undertaking. And what I say here is, the common denominator in every communication sent by this child support agency, remember, they always rely on presumptions. They call you an obligor. What we're doing is, okay, well, you know what? You've been calling me an obligor. You're telling my employer. You're telling the bank. You're telling everybody I'm an obligor. Where is the proof of my obligation? Where's that proof of the undertaking? Because an obligation is an agreement. It's a contract. When did I agree to this contract? I don't recall signing anything. Okay, and that's what we're doing here. Again, excuse me again. I go over what the an obligor is. What is an undertaking? Okay. I go into all that. Now, this is what was in right here. This whole body is what Bob sent out. Okay? And this is the reaction. Okay? And another subscriber of mine sent out the interrogatories, and he got basically a response similar to this. Now, I remember I told you guys we're being watched. Okay, I wouldn't be shocked if my channel or my name is on some memo somewhere that these people will be on the lookout for this. And what their attitudes are now is, you know what? We're not going to comply. If they want us, they're going to force us to take them to court. And again, I told you guys that the downside to this is it costs money. But start saving your money. It's worth it. If you go to court, see if you can get a waiver because you can't afford it. But start saving your money because they can't go anywhere after this. It's going to be hard for the Supreme Court to cover their asses when they can't prove that they don't have the basic requirements to call you an obligor. Just the basic order of support lacking a judicial signature is enough to vacate it right there, to void it out. Okay, there's plenty of case laws out there to back this up. All right, so what I'm showing you in this video is proof that what my paperwork does. I box these people in. I put you in a position to win. Okay, again, I'll say it again. There are no silver bullets out there. Okay, you're not going to be able to send out one letter and scare these people. What I've always said, I've been saying to you guys for a few months now, it's a process. It's chopping down the trees. It's getting the ball rolling. And it takes a little while, okay? But we have to do it because they don't play fair. We know that. We already know that they're not for us. But if we could box them in, we can win. All right? I already had a couple of guys, using this method are successful. James in Ohio and Andre upstate, New York. And I guarantee you, Bob keeps pushing these guys, and he's going to do it because he hates these people. Okay. All right. So listen, I just wanted to show you guys, the reason why my writing style and what I do to these people, boxing them in, and then the next move is to go to a higher court and have them prove And when they can't prove it, that's when they start making deals. That's what they did with Andre. All right, guys. Enjoy the rest of your day.